This is the Earth to World Broadcasting Network.
Welcome back. I'm Greg Frick from HFO Investment Real Estate. Today we're going to be talking with Jonathan Clay, the legislative analyst for Metro Multifamily Housing Association. Metro Multifamily Housing is the largest multifamily ownership association in the region. And today we're going to talk a little bit about what happened in the Oregon legislature last year and what we'd look forward to moving forward in 2012. Thanks for coming.
Thank you, Greg.
You're welcome. Why don't you give us a little background on the Oregon, we've heard a lot about Oregon's landlord-tenant law in the past few years and kind of what the role of Metro Multifamily's been in regard to advocating for apartment owners.
Well, Metro Multifamily Housing Association has been a trade group for landlords for the last 15 years. We manage approximately 150,000 units, and we've been a big player down in Salem for many years. We are one of the few landlord interests that are represented on the Landlord-Tenant Coalition, which is a group that meets before every session to hammer out possible changes to the Oregon Chapter 90 statutes.
Okay.
And we had a coalition bill for 2011, which was passed, and we had one for 2009 as well. This year in particular, it was interesting that the House was evenly split between Republicans and Democrats, 30-30, which meant that the whole session had the brakes put on it, and there weren't too many controversial bills that were passed. So that was pretty much good news for us as well, because 2009 was a really loud session with a lot of changes.
Right.
That manifested in changes to our forms and a lot of outcry and confusion. So it was nice that we had a quiet session, and both sides of the coalition agreed that we would not do anything controversial.
And what is the relationship between the coalition from Metro Multifamily and the Tenant Advocate Groups? I mean, is it kind of a working relationship where you go down to Salem and kind of each do your own side, or you?
Both sides work harmoniously together for the most part, and it's just been the precedent that has been for like 20 some odd years, where they agree to come together. They agree to hash out what each side wants to change to the landlord-tenant statutes, and they make a pact with each other that if they come to an agreement on a coalition bill, that they're not going to try to pass any other changes to Chapter 90 without it going through the coalition or without the consent of the coalition. So both sides have the benefit of knowing that if they agree to these terms, nothing else in Chapter 90 is going to change that year.
Oh, okay.
So that's why those compromises are reached, because they know that they have the assurance that both sides have buy-in to the changes.
But then it still has to get through the House and
it still has to get through the House and Senate and through the committees. But the legislatures have gotten used to the idea that changes to Chapter 90 come through the coalition, and they really like the fact that that coalition bill comes before the committee. Both landlords and tenants testify positively for it. It sails through. There's no fighting.
Right, all the fighting's done at the front end.
Exactly. So and each year, one by one in committee, they praise this process and appreciate all the effort that we do to have a good bill that both sides can support.
Who else is on the coalition? Is it?
The Metro Multifamily Housing Association, the Rental Housing Association of Greater Portland,
okay,
and the Oregon Rental Housing Association. It's a statewide group. Those are the three main groups that are there to represent the landlords. On the tenant side, we have the Oregon Law Center, we have the Community Alliance for Tenants, We have Lane County Legal Aid.
Oh, okay.
So those are the 6 main groups.
They get together for the coalition.
Mm-hmm.
Got it. Okay. So what were what were the landlord, I guess, wins and losses in terms of bills? It didn't sound like there was too much last year, but
Well, yeah, there are about 3,000 bills that were introduced in 2011, and of those, we were monitoring 48 of them and
Okay.
actively tracking about 17.
okay.
And the vast majority of those we were able to either kill because they were bad bills, or we were able to change them so our position could be neutral, and then the rest of them we were able to call a win where we supported them and they passed.
Got it. Got it. And so, are there bills ever brought up that are coming not part of the coalition, where you get the House or the Senate coming up with their own? We think this may be good for landlord-tenant laws, and the coalition's saying, "Wait a minute,
That I'm sure that scenario's happened in the past. There's always bills that would affect our industry that wouldn't pass through the coalition because those laws aren't in Chapter 90, which is the landlord-tenant laws.
Okay.
If there could be a law that would affect towing, and that would be in towing statutes, or a law that
Right.
would affect housing vouchers, and that may be in other parts of the statute code, and then outside of the purview of the coalition. So we're having to monitor all sorts of bills.
So the coalition's really looking at 90,
Yes.
and then there's other laws that get passed. It's kind of not specific to multifamily, so to speak, but it gets thrown in there. Towing.
Mm-hmm.
Okay.
Carbon monoxide alarms.
Right.
Perfect example of having a huge impact on our industry, but not in Chapter 90, and did not go through the coalition.
So has the coalition looked at expanding at all beyond Chapter 90? Is it specifically a coalition just for?
I think that they would feel they wouldn't have the authority to
do that.
expand into other statutes that aren't expressly for landlord-tenant. It would be nice to just take care of everything in one
Yes.
bill, but
Yes.
it keeps us on our toes, or me at least, as I'm the key researcher and tracker.
Of all that, yes. So what were some of the specifics this year? It didn't sound like there was a lot of in the 2011, but
we were able to kill some really bad bills. For example, there were 2 rent control bills that make all landlords shake in their pants. I mean, there was one that was designed expressly for manufactured housing communities, and there was another that was attempting to overthrow a prohibition on local governments to enact their own rent control rules. So we've killed both of those. There would have been a bill to automatically award the legal fees to a prevailing party in a civil rights case, or excuse me, specifically to a tenant prevailing party, but not for the landlord. So we fought and
it's a little one-sided there.
Right.
Yes.
Right. There was a bill that would have required energy audits per unit, and for that data to be disclosed to the tenant at the application stage. We thought that was just too much to ask.
Right.
There was a bill that would have required voter registration cards be offered to any prospective tenant. We thought that was.
Oh, really?
There's already so much information
Right.
that needs to be disseminated at the application, at the agreement stage. We just thought we shouldn't dilute that important message with other causes.
Right, exactly. No, I agree with that.
But there was even a bill that would have mandated television antennas to be constructed on top of multifamily buildings.
Now, was this coming through the coalition, or was this kind of stuff that was just kind of brought up?
Extra stuff
that was
outside of the
coalition.
coalition.
Got it. Okay,
Yeah.
so this is a good example of these laws that get brought to the table will have an effect on multifamily. Maybe not specifically geared towards that, but
Yes.
yes. Well,
So it does. It definitely keeps us on our toes. We were able to, and speaking to that, there's all these bills that get dropped that there was no intention of having a multifamily consequence, but there was. Like, there was a bill that was trying to address charter schools that would go bankrupt, and students wouldn't be able to get their records to graduate because they would just leave in the middle of the night. So, you know, there were a lot of education entities that were supporting this bill that would have made landlords responsible for any education records left over by a tenant. But it was written in the first draft that it seemed to apply to all landlords, even
multifamily,
even housing landlords, and
Wow.
not commercial landlords. So,
Really?
so when we were able to get the changes,
Okay.
made to that bill, but that's just another example of having to pay attention to everything. There was a bill for that the sheriffs wanted. So when they felt that they needed an extension to secure the writ of eviction, that they were able to do that, but there was no provision to disclose that to the landlord. So we made sure that if they chose to do that, they would let the landlord know
Right.
that they were going to take more than the normal 30 days to complete the writ of eviction. And of course, the courts had a huge bill to change how they charge fees for various court services, and their initial draft was a pretty steep increase in the FED, or formal evictions, and we fought hard to have that increase be much more reasonable. So.
And you got it.
Oh yes.
Oh, good.
So
good.
instead of being $105, it's now only $75.
Right. So moderate increase, but nothing
Yeah.
like what they were shooting for.
Exactly.
What what other changes, I guess, going? I mean, almost 2011 is almost over. What are we looking at moving forward in 2012 with the coalition?
Well, the coalition bill, the agreement that both sides came to, was a housekeeping measure for the most part, and some of the wins for the landlord was the fact that we no longer had to disclose all the rents, fees, and deposits at the application stage. That we got to save that for when they signed the rental agreement.
Oh, okay.
So that was a win, as some of those things changed depending on how that application screening got back. There was a snafu between the statute language for carbon monoxide alarms and the administrative rules that were passed a year later. So we got the statute amended just to reiterate that the carbon monoxide alarms were only required when there was a source or a conduit to a source, which was a big deal for, say, a multifamily housing owner that had maybe an oil or gas heating source in the basement, but there were no sources in the individual units
Right.
above, and there was no direct communication between those units and the basement.
Got it.
Would those units all have to have the alarms? And the answer would be no.
Oh, okay, so that's changed. Okay.
Yeah, we got the sales threshold for abandoned property raised to $1,000. So when a tenant moves out and they leave any materials, if you're able to simply donate it away if it's less than $1,000 of value, and it used to be $500. So
Well,
it's
that's
just
good.
nice that you're no longer having to have a formal sale
Right.
and advertise in so many papers and follow those rules if you're dealing with property that's worth money.
Okay.
And then there was a change. In 2009, we were able to, or there was a law that would allow a tenant to, if they were renting a property that went into foreclosure, they could request that their rent be paid by the security deposit that the landlord was holding. And there were instances where tenants would take advantage of that, and then say the property comes out of foreclosure. Now there's a method that the landlord can get those security funds back.
I can make them go back and reimburse the security deposit. Not that we had a lot of defaults in multifamily in this market, but
Right, but
you get a few here and
single family
there.
homes,
Right, right. Again, this is
we represent.
another measure where it's
Mhm.
single family. rentals kind of gets tied into the multi.
Oh yeah.
Yes.
Oh,
Okay.
oh, definitely. And there was some other changes. If landlords would break, screening fee or rental reservation policies, there was a charge of $100, and now that's $150. So, say if a landlord promises a unit to tenant A, but they actually rent it to tenant B, and there's documentation that they promised to tenant A, then that tenant can not only recoup any deposits or rent deposits that they made, but also the landlord's on the hook for a $150 fee.
An additional $150 on top.
Exactly.
Okay.
And if, say, the landlord takes a screening deposit or an application fee, but takes that fee but doesn't actually run the screening, then the tenant is then able to collect double that fee and of course the $150.
On top. Okay.
Yeah.
Wow. Okay.
So, and then the last bit about the coalition bill related to and again, this is like housekeeping, so it touched so many things in little ways. There's rules for domestic violence victims, and if the victim of a domestic violence incident wanted to leave their lease, that they could without penalty, as long as they gave a 14-day notice to the landlord. The law changed that would allow that domestic violence victim to take any family members that she was living with her. And
so they could break the whole lease and.
Exactly. Whereas before it was only the victim and any minors, and if they were living with other family members, that they would then be forced to stay.
Got it.
So now the whole family gets to move if that's what they want.
With a 14-day notice.
With a 14-day notice.
Right. Okay.
Yeah.
What was on the coalition on the tenant side? I'm interested to know what I'm sure our viewers are too. What are the tenants coalition groups really pushing for now? I mean, I know a couple years ago we had no more, move-in fees and cleaning fees, and it was a very line item of what you could and could not charge on move-in. What is kind of I hear the dreaded word rent control.
Yes.
Is there any other kind of things that we're seeing big pushes from the tenant groups that we could see that we're going to continue to be battling with?
Well, fair housing issues have really trumped it this year with the audits that have happened in Beaverton and in Portland, and that has I see that Section 8 housing choice vouchers, that there's a lot of movement for them to be considered a protected class. That would be one.
Say if you're on a voucher program, you would be now put in the protected class bucket, so to speak.
If you had a voucher and you came to a private conventional landlord, and the landlord in theory then at that point would no longer be able to say, I don't participate in that program.
Right.
The landlord would have to accept that voucher, and if in theory all of the other points of the rental criteria that applicant would be judged by, employment,
credit history,
other income,
right,
credit history, if that voucher holder passed that other criteria, then that landlord would have no choice but to accept that voucher. That would be one scenario which we've advocated against, because we feel that the Section 8 housing voucher is not income. It's
right,
a program that it has a lot of other restrictions.
Yes. As
far as the length of the tenancy, it's been a piece of contention between both sides.
It has. So that's kind of okay.
Mm-hmm.
So moving in 2012, is that what other?
Yes, I would say rent control,
Okay.
Section 8. There'll be another bill on that, and there's also there's possible. I think there's going to be calls for regulation to landlords' rental criteria as it addresses criminal history.
So a change in, or
That-
just more specific on?
That right now, landlords are able to say, my rental criteria dictates I don't take anyone with a criminal history.
Right.
And there's a lot of movement behind this idea that if someone has already served their time and it's a non-violent offense, that they deserve to have a chance at housing, or that the rules and criteria that are dominant are just so strict that there's too many people that need housing, and that should be lessened to a degree, which makes landlords very nervous because where's the liability fall? If they allow someone to come in that has this criminal past and there's some issue at that property, are they going to be held responsible because they approved
by the other tenants
of
or
them?
Exactly.
So
So you're pushing back on that one.
It's a hot potato, yeah.
That's the. Okay. Now, does do you guys get involved at all with the kind of the regional inspections, annual inspections, or that we see in Gresham? Portland's been talking about doing it. I know they have it in Salem.
The association has always believed that mandatory inspections are not a good way to allocate those precious dollars to further quality housing. That there are the bad actors that are in the landlording community, and that those dollars that fund inspectors and fund the safety nets to make sure that people live in housing that's up to code should be geared towards those offenders, and not those funds spent to inspect all of the law-abiding and code-complying landlords. I mean, it's just a huge expense.
Kind of go after the bad apples and see,
Right.
Spend your time on those.
Mm-hmm.
So as an owner, where can they find information on kind of what Metro Multifamily, what you're doing specifically, in the upcoming years? They go to the website. Is there a section within the Metro Multifamily website where they can see legislative updates? Or?
We certainly do have a government affairs page as a part of our as a part of our website at metromultifamily.com.
Okay.
And of course, any of the staff is able to answer basic questions. Good. And get people, the forms that they need, or, we also do a lot of education for the industry to understand rights and responsibilities for landlord-tenant law, federal fair housing law, best practices for housing providers.
Oh, good. Okay. Well, thank you again for coming. It was very informative. And thank you again for watching on HFO-TV, and we'll see you next time. Thank you. Feel free to learn more about our firm by visiting our website or calling us directly. Thank you.
This is the Earth to World Broadcasting Network.